Not that loud. Good evening, everyone. Thank you for your patience. As you can see, we have a very large group. So we'll get through this. We'll have everyone that wants to speak that signed up. We'll give you an opportunity to. But with that said, I'm going to call to order the Rights of Way Subcommittee public hearing on behalf of the State of Rhode Island Coastal Resources Management Council. It's in the matter of CRMC file number 2020-11- excuse me. Can you not hear outside the doors? Are there speakers out there? Is that what it is? That need to be turned up? Can you hear? Is it coming out of that speaker? What is the speaker right behind it? I know there is on the other side of the glass. I saw it.
Which should be good. If you pull it up, you should be able to follow on. Just turn them on and speak close when it's not.
Is that better in the back? No, nothing's coming out, sir, on those speakers.
Let me check. You can keep going.
He's going to check on that. This is just introductory right now, but back on the record, it's CRMC file number 2020-11-084. It's a Spring Avenue extension. Today is Monday, September 15, 2025. The location of the hearing is the Westerly Town Hall Council Chambers at 45 Broad Street, Westerly, Rhode Island. So before I'm going to ask that the record reflect the subcommittee members that are present here this evening, as well as CRMC staff. Before we get into the formal agenda, I'm going to turn it over to Executive Director Willis for some opening remarks.
Thank you, Mr. Chair, and I believe this microphone is not on.
All right,
So
which one are you?
He's good. Try it. Try turning.
Great, now it's on.
Speaker.
Thanks, Sean. So thank you all for your patience. Very much appreciate it. I will speak up as well as speak into the microphone. But as the chair said, we are here in the matter of the Spring Avenue extension evidentiary hearing to determine whether or not Spring Avenue extension could be designated by the state of Rhode Island through the Coastal Resources Management Council as a public right-of-way to the shore. These evidentiary hearings are similar to what you're seeing here, although this one is highly attended, much greater attended than others, but they will proceed in pretty much this fashion. We will have meetings in the town of Westerly on this matter. If it takes one meeting or several meetings, we will take that opportunity to have as many meetings as it takes to exhaust evidentiary hearing processes. That means the attorneys will have their chance to have their say in whether or not they believe it should be public or not, but it also allows the public to have their say as to whether or not they believe Spring Avenue extension could be designated as public or not. We are basically doing a little bit of a hybrid type approach tonight, where we're having the public speak first. Normally, the town that is requesting a right-of-way be designated would go first. But in this particular case, we're having the public go first. Once that is exhausted, we will have the attorneys go. And then after the attorneys are done, the public will have another chance to speak. Essentially, what the process would allow is normally the public has the last word. You will still have the last word, but you'll also have the first. So I just wanted to explain that. Now, having a second crack at the apple tonight won't happen, but you will have the ability to come back on the second night somewhere in the future and have the last word, but we'll explain that in a little more detail. As I mentioned, tonight's agenda is only for public comment. There will be no attorneys making presentations tonight. We have well over 40 people that have signed up so far, and I understand there's a third sign-up sheet that is getting populated. Not everybody that put their name on that sheet is asking to speak. However, given the sheer number of folks that do want to speak, we will probably be limiting you to the amount of time you can speak so that we can have everybody have an equal opportunity to get up to the podium and have their say. When you're speaking, and I think you're all familiar with this, we're very familiar with town hall proceedings in Rhode Island. If someone in front of you has said what you wanted to say, please don't repeat it verbatim. Maybe bring it down, synthesize it, or just say, I agree with what so-and-so said, here's why, and maybe we can get more people to have their say in that fashion. That's about all I wanted to say for now, other than just to reiterate, this is the first of probably several evidentiary hearings. We will discuss at the end of the meeting tonight the potential for how regularly are we going to hold these meetings from this point forward. We might even determine the date for the next one, but we might not. I just want to let you know that the subcommittee is ready and available to hold several of these meetings, and we'll work on that schedule beginning tonight. If we don't get dates settled tonight, we will soon, and we will let everybody know what that schedule is. All right. Other than that, I think I've done enough housekeeping for the evening.
Thank you, Mr. Willis. At this time, I'm going to call on Council Attorney Hartman to make some comments. Well, you're muted. Oh, right again. Yeah.
Thank you, Mr. Chair. So the only comments I would like to add tonight to what Executive Director Willis said was that this is an opportunity for the public to comment. Part of that process is we want to have an open discussion. We want to hear what the public says on a transparent basis. We think the best way to do that is to have an unfettered discussion, meaning there won't be cross-examination of the public commenters that come up tonight. This part of the process is different than what will take place later on at a later meeting, where the attorneys for the proponents of Spring Ave extension will have an opportunity to put on their case. The objectors and the interveners will then have an opportunity to make their points to that case. That's not tonight. What's tonight is public comment. So we want to hear what you all have to say. That's all I have, Mr. Chair.
Thank you. So as indicated, I've got a list. I've got two in front of me, and I think there's a third one out there. So we're going to start on page 1. When I call your name, I'm going to ask that you come forward to the podium, introduce yourself and your address, please. And as Director Willis said, try to limit comments to about 3 minutes, making the most poignant points that you want to make as it relates to what you want to speak about. If at another hearing, you need to say something else in response to something that was said after you spoke, you'll have an opportunity to do that at another hearing. So with that, first one is Richard Langseth. You could come forward, please.
We can't actually have that time to get the stone raised.
Excuse me?
This mic purpose? Yes. Richard Langston, Club 1 Farm Road, Warwick. The CRMC subcommittee must follow the Weequahic Fire District, the promise of the old Weequahic Beach Company. The beach company promised to dedicate Spring Avenue extension as a public right of way in the tidal water area when it filed the Weequahic plat maps. The 1940s beach company warranty deeds to Albert Spicer, Charles Hickok, and William Demarest spell out that the Weequahic streets are equivalent to Westerly public highways and that the Spring Avenue extension is a right of way for the tidal area. Following an 1832 decision of the U.S. Supreme Court, the fire district is held to this. I asked for time. A recent Brown case on the subject is Finn versus Gray. Argued for Indians by Dennis Sherman, who was also the counsel for the beach company before it was resolved. He was also the counsel for the people in the Shelter Harbor Fire District, where he argued that you must get consent from all the abutters in order to deny a right of way, to deny your previous dedication of the right of way. In other words, what they tried to do is they tried to deny this right of way in the Woodland Park Fire District. And I'm sorry, in the Shelter Harbor, they did not ask for permission from the abutters. Now what's happening is Mr. Sherman is also the counsel for the beach company, and what he did was he attempted to turn away that promise. He attempted to say, no, we did not make the promise. But what he didn't do was talk to the abutters. Then he went to Satchel Point with the Satchel Way and offered the same argument where you cannot deny your own promise because it's just crazy. You make a promise, you have to keep the promise. Now what we have with the fire district is they've assumed the promise because they took over the beach company and now they're held they're held to stop making challenges to the promise. And what I'm saying here is that the subcommittee must tell the fire district to stop attacking the right of way. Now, I'm personally involved in this because I asked the subcommittee about a year ago to present this argument to the subcommittee. And then the lawyers got together and they all agreed that I should not be in here, but that I should come here tonight to offer my advice and arguments. So therefore, I feel that it's great that you're allowing this to happen. And I wrote down the full argument here, which I presented to Wilson. Appreciate your reading this because I'm not as articulate with 1,000 here as I am whenever I speak them.
Thank you. Thank you. Next is Bob McCann. What I am going to ask you to do when you rise, state your name, your address, and right off the bat, just say I'm here in favor or I'm here in opposition, and then you can make your speech, please.
In 81 North Bank Road, which is Rhode Island, I am not for opening up spring understand. Good evening and thank you for the opportunity to speak to you this evening. So my name is Bob McCann. I'd like to share my perspective on this whole regarding extension. History is an important guide here tonight. As early as 1940, the town of Westerly itself investigated this question of committee led by its own highway commissioner and determined that Spring Avenue extension was not a public right of way, and its conclusion has stood unchallenged for the last 80 years. The town has never touched the property, because it wasn't the town's touch. Simply, it is private property, owned by the Beacon Fire District, and as we all know, private property and private property rights are the same in this agreement of ours. Spring Avenue extension is set up contains a past beach. In fact, the area has been fenced and overgrown for decades, which explains why I and others in the community have never observed any attempting to use it. Literally, not on the first three. And historical record of physical evidence the line. Spring Avenue extension has never been public. This is why there were 64 private easements granted by the predecessor owner of this parcel between 1945 and 1964. Again, 64 of them, and each are recorded in the town of Westerly land evidence records. Furthermore, in 1942, in the middle of World War II, our United States federal government were granted an easement from the then owner of Spring Avenue Extension. Who did our government, with all its resources at its disposal, determine that to be? It wasn't the town of Westerly. The Weekly Beach Company granted an easement for Avenue Extension to them for the cause of our national defense. It defies logic and the law to claim that Spring Avenue Extension was a public right of way. I respectfully ask the CRMC to confirm what the evidence is consistently shown. Thank you for your time and your careful fact-based review of this report.
Thank you, sir. Next. Okay, Jim Brown, but I think he signed it, but said does not wish to speak. Is that correct?
Correct.
Okay, thank you. Fred Preel, if I'm saying it right, Preel? How are you?
Thank you. My name is Brendan Brown. I've been like distributing this. For as long as I can remember, the investment. Property investment. Never functioned at the. All that time, I've never seen this. That use this thing. Reason is always the long is it's nasty. Even before the fence was done. '70s, nobody ever used it. Fishermen, and well, always made less the speech you follow. For fun. We will see. There's never been a year ago. The town of Westerly, made this flag property, public right plans, understood on the state. In 70 years of time, legal record, actually only one. And your little. The problem. That was very good. It's very heavy. More. It's very heavy extension, because not machine. It's certainly not. I expect that the urgency was fast, very nice. Never had people take us that. Thank you for your consideration.
Could you just state your address for the record, please?
Yes, 14 movies that.
Thank you, sir. Matt Zola.
Good afternoon, good evening, my name is Matt Zola, 46 Sunday Road, Westerly. I'm in favor of the issue here is whether the extension constitutes public right of way. The record shows officially at the end of this time. The extension has never been accepted by the town as a public right of way, and it has never been open to the public, and it has never been maintained for public use. In fact, only that it can be private on this issue. There are many other roads throughout Westerly that are listed on town plans. And the town does not even get into the fact of public roads. With Spring Avenue extension, physical evidence is conclusion. The extension has been fenced in, overgrown, and discussed previously. rendering it impassable. As someone who's going in the area, I can attest that it's in the better seen tests the shoreline through this spring avenue extension. Equally important is the historical precedents that confront this understanding. As has been previously mentioned, in 1940, town itself created a committee to investigate the rights of way. And that body found that spring avenue extension was not a right of way. That official finding has never been reversed or contradicted. In land use matters, the council charge is relying facts, law, and precedent. The evidence here, I believe, is overwhelmingly consistent. Spring avenue extension is not a right of way and never has been.
Thank you. Emily, Mugge. Good evening.
Hello, everyone. I'm Emily. I've had a home in Westerly at 89 Westerly since 1947. Lived here full time since 2009. As a child, I walked to Indian Beach almost every day in the summer away from fire district. As did everything. The path was served the community as the only access to the Indian Beach for many generations. Work always open to the public, especially fishing, in the mornings and evenings during summer, and fully open to the public during the long season. By contrast, no one has ever used the so-called Spring Avenue extension. That area is always an overgrown mess of shrubs and full of poison ivy. No one even had a name until this dispute. In 1940, the town conducted a full review of rights of access to the ocean, covered closely by the Westerly Sea. And Spring Avenue extension was not listed, even though every legitimate public access was. In the 80 years since, the town has never once maintained one. Because it was never the town's to maintain or to open. A public platted road that was supposedly so prominent and so frequently used could not have been invisible to me for my entire life. This is not just about precedent. It's about honoring the truth of how our community has lived for generations and examining the unemotional facts. To now declare Spring Avenue extension would be an unjust taking. I respectfully urge the council to vote this purpose and management. Spring Avenue extension has never been and is not now. Right. Thank you.
Thank you. Next on the sign up is Glenn Flostoff, but not indicating if you wish to speak. Okay, thank you. Rich Hittinger.
Thank you very much, Mr. Chair.
How are you?
My name is Rich Hittinger. I'm the Riverside Subdivision Run over News. I live in Norwood, but we represent many residents in the town of Westerly. I don't have a prepared statement tonight. However, we are under the understanding that this was a public right of way in the past. It was in fact listed by CRMC at some time in the past. And we would like to see this right of way reopened so that it is public, so that it's clear that there's access. At this point, we understand from our members that they, in fact, do access this area, and they do. In addition to using the boardwalk area, they do this at times when there is no security guard there preventing access. So they go at night, use that access and fishing in the area is of particular interest to our members. They also access the area in the shoulder seasons, so in the early spring or in the late fall. So we're very much in favor of seeing this designated clearly as a public access. Thank you.
Thank you. Next is Mary McCormack.
My name is Mary. 68 Manor Avenue, Western. To introduce myself, I'm a Robert Sheldon Parker. And my husband and I have a house in Wheaton for the past 57 years. Coincidentally, one of my best childhood friends grew up in the house directly abutting the Spring Avenue extension. Thus, I'm very familiar with this area. I have never once in 70-some years of living seen anyone use the Spring Avenue Center to access the shoreline. Some people would cut across the Weeds lawn that live there, and mostly kids, and make the Weeds serious, but they were just over across the room. The evidence also demonstrates why this land has been investment for as long as I can remember. It shows that it was always overrun, except after Hurricane Terrell in Maryland cruise and swiftly across into West Coast. The boardwalk or the weeds down Huston's Lawn was the only way to the beaches. And that is the same boardwalk as we still use today. For many decades, of fence and huge vegetation blocked access. Never once did the town of Westerly maintain or use in any way. The facts of the record are clear. The so-called Spring Avenue extension is not and never put into public. It is owned and privately owned property. It has never been opened as a to the beach, nor has it ever been maintained as such. Some people claim that because the Spring Avenue extension appeared on a Stanley town map from 1939, that makes it public. However, I live on the border of Charlotte and Dove Avenues, and they are both on the same 1939 map. And they distribute private roads. They are both still listed on the town's activist, just like the Spring Avenue extension. They have never been maintained. That is the same set of facts for many other private roads that appear on the old stand. So being on the flat does not make sense. I respectfully request the Coastal Resources Management carefully review the evidence. The record shows that the Spring Avenue extension has always been private, not access. Thank you.
Thank you.
Right. If I'm second, having difficulties with people on the line.
All right. We'll take a momentary pause. You want to test it, or is that good?
Right, should tell.
Yes, That's one degree exactly.
It's good. Yes, thank you. Next speaker, Scott Wakeman.
Evening, board. My name is Scott Wakeman. I am a homeowner in Westerly around the east. My family and I have had a house there since 1995. And we started doing weed log in 1962 when this was put down in the Springfield area. And they ultimately became homeowners as well. One of the things that we loved to do when we were kids, beach. We thought there were two beaches, Fenway, which had two access points, both over by the Big Well Fire District, and there was the beach. And there was one access point called Boardwalk, which is immediately across where the Keith sits at houses. There were no other access points. And from my early childhood at the age of 5 to 6, the area in question was highly vegetated and untested. No time during my lifetime with the Big Well have I ever seen a single soul use that property. What I would like to point out, though, is that the Big Well Fire District offers substantial amount of public access to this existing. The restricted times only exist for 3 months, 5:30 in the evening, 9:30 in the morning. Anyone is free to walk that boardwalk and go down there and just the beach. And there is security there from 5:30 usually until midnight, and they not then people pass it during that time. For the 9 months, September 15th, 15th, and so can see. So for that boardwalk, there is a 90% public access during the calendar. I'd also like to back up what's been heard already, that the 1940s commission examined public access points in the town of Westerly in a very thorough review that included the Big Well Fire District and found no evidence of any public right of way to the beach across fire district. And for that, I am thankful for your time and appreciate the considers the facts that I've seen.
Thank you, sir. Faye Weber.
They have a testimony stated that relates to evidence incorporating some testimony that is already been submitted, specifically rules and my family and I have to be influenced. I can read it in my name, and entered into the record.
Can we take it? Yeah, you can read it into the record. Yeah.
You were a concern. I had a grandfather, my extended family, and predominantly lived. Family has predominantly lived in town of Westerly, frequented the beaches for at least 7 generations. And before you this evening, you will dedicate to the photos that have been handed down in our part of my family's private collection, which are ancient documents more than 2 years old, previously submitted into the record. You gave my own personal testimony to the testimony knowledge you gave. The photos on page 1, labeled readable, Oceanside 1930s. Number 1, 2, 3, 5, and 6, and 8 depict on Great Pond, Mary Hadlock on the beach with a beautiful head in the background. Its original location in 1936, as written on the map. Best knowledge and belief, Area owned the house for lot located in what is now known as the Fire District. And these photos were taken prior to the fire district's incorporation in January 1937. Photos on page 2, where we call concept in the 1960s, number 9, 10, 11, 12, 13, 14, depict a Hunt's feeling along the sand feeling, Linear Avenue, having picnics in the 1960s and standing on that. To the best of my knowledge and belief, we or anyone else in the world on the house is in what is now known as fires. The entire public area was always open to the general public. Photos on page 3, unlabeled, is a continuation of page 2. Number 15, 16, 17, 18, depict walls upon family picnics of the same. Decades my family are frequenting the area and access the ocean and the pond without issue. To the best of my knowledge and belief, it was our right that a privilege granted to us by the Westerly Fire District. We did not get nor ask permission from anyone, and no one said otherwise until approximately the late 1990s. To the best of my knowledge, if we access the ocean side of the beach, and we walk on a path 91. Close to the last house, which I believe is the reading cottage on the right hand side of the road. Near Adams, Spring Rock. Before entering, the road continues and leads to the sand trail, where I might family also would ask the working on the pond side, my father's street. On the left hand side, the sand trail further down. My mother Mary finds from my sisters and I to the oceanside beach. In our way in my station wagon, and to the best of my knowledge and belief, right close to the last house on the right of the popular spots to this day, which was the entrance to the beach from the public parking area now fenced off and overgrown. We noted that house, that last house, has extremely considered. To the best of my knowledge and belief, we all got out of the car and walked down the sand path, not walk to the beach. Recently confirmed with my older sister, who is now 78 years old. Her memory said what they had, we used to access the ocean side. They were not important. Also, that there was a road behind us, Spring Avenue, where we ended and walked down that path to the ocean side, where we call, we not walk off the underwater by the strong waves. We went to help apply someone that gave us this vivid memory. As frequently mentioned, you also access the onside women, on down Sand Trail, Linear Avenue, and football to the left. A sandy beach, grassy area in this sheet. Multiple other family members and friends also drove sheets down to have picnics, and clearing, crafting, and other pond side activities. The best of my knowledge and belief, we were going to stop questioning the problem in any way. And that was on or before, on or about the late 1950s and early 1960s. In fact, I myself am portraying pictures showing me in the back of my dad's sheet on about age 9, since that the date of the name on the back of those pictures. Thank you very much for your time. The pictures are. It's in the video.
Thank you. John McLean.
Well, thank you for today. I'm Dr. John McLean. I'm an active scientist and person, you know, and this probably has always been access to. I actually did my PhD at the University of, we used to take, field trips down to the, that beach. They would take, go down to the regular basis, we would have, projects and we get down to the beach and other open access areas. From the state, we take, samples of the soil, we take excursions, look at the animal food plants, that are along this, shoreline. Also take surveys of birds and so on that are in the areas of ocean. We always use the, basically, when I used to what's called a weed and path. We were told not to use some woodmark. We used the path that went down. This was in the 1970s. I lived in, right now I live by the way in Fort Montrose, or Westerly, Rhode Island. On this, excuse me. And basically, I still go down on a regular basis. I used to, I'm a photographer, go down there sometimes in the morning, sometimes in the evening, and yes, I appreciate that it does have open access of it. But I also would have recreation to the beach. One day we use that type of beach where it's very open, where it's shown different types of sails, different types of shells. This is an open access beach. It's 2 miles long. And it shouldn't be fully open to all of the Rhode Island citizens. I submitted a document. I didn't realize how many people were going to indicate that it was not open. Probably my document that I had submitted to the council already has some of the stuff that I given to the class and with the Attorney General Peter. Guys look at this. I don't want to go into that kind of area. I wanted to, everybody was saying that was not open at any time. It was open in the 1970s. And what is that? We could go down there on a regular basis. We could go down midday. Wanted to make transit information from morning to evening. Sometimes midnight. Okay, we looked at it at a different time. So we went down there on a pretty regular basis. Yes, this property was open. I didn't realize that was going to be a component of the presentations, but so I'm taking the presentation back listening to the council, but I do want to make sure that it's on record that I did have an understanding of this in the 1970s, and I've used that access at other times as well.
I'll call up Dan Davidson, but just ask you to hold your comments until I get the thumbs up. It's back on. Thumbs up.
Good evening.
How are you, Dan?
It's a big crowd. I'm getting Commissioner Ryan. Pat, I have shown my yours. So sir, I can't believe people are standing here tonight. Very false witness. That was not very false witness, but one was a solid concept. And as people grow older, they actually become sharpest. They believe their own lies. And that's what I see here tonight. Everybody that wants something for themselves. He's golden, okay, you're around. We all had that in the places for sure. Even before we were commissioned, even King Charles said, we had an animal for sure. And this is the way it's been. I was ready for the Constitution. And this day, I go ahead and show what I want to. I'll walk through the woods and one push people. Walk past the security guard. They cannot be. Sometimes you have to stand up yourself and just say, this is my shore and I'm entitled to it. However, the problem is really the gentrification of the shoreline. You have to stand up and explain to people that buy property that there's no such thing. Private PG version, or never had that, no adequate privacy anywhere. And I guess the right thing to do, and I know the thing that they're compromising with small. Is it 9 months out of the year, for 3 months of 8 or 9 hours during the day, you can go there, but there's only a handful of parking spots there that we can go to drop off and you can't make accommodations for that handful of people, especially if an elderly person drives up and parks in the Westerly lot and show off. What if that elderly person won't use that walkway or the main line? What do they do? I'll tell you what they do. I brought my mother there during the day. And the lady told her, well, around the sand trail to Charleston. That's really, I really happened. Gotta say that. So, between the haves and the haves on, you know, with these people, I feel bad for them. They were born with money, had certain, you know, had certain things where they finally want to keep things for themselves, but that's just the way it works. I'm not flying around. Everybody that I was with, Spring Avenue Road doesn't really need to be a right of way if they can just open up their right of way. They don't really need one, right? That's the compromise. But because they refuse to have to open up their right of way. But not just that right of way, it's just typically on this first, right? So those much deeper right of ways from Tree Point all the way to one base out and run both seven. I think that's some major problems. And the weight of this weighs on CMRC shoulders. This is going to keep coming back to that because we're not going to stop. And so we can step forward on every public.
Carrie Mulligan.
Good evening.
How are you?
My name is Terry Morgan. I'm assistant attorney. I will be brief. My husband and I have lived in Rhode Island, and I've been in the area of my life. In fact, I worked at the old LMX to help pay for my college education at URI. We now live full-time in Cape Cod. My husband and I volunteer extensively with members of St. Clair Church, who work with the Worms Center and Johnny Haven. I say this because Westerly is our lifeline. We love the community. But the facts are clear. The Spring Avenue extension is not a public right of way. I know some people don't like hearing that, but it has always been private property. It's never been open, never been used, and never been. For decades, it has been blocked by fencing and over. I've never once seen anyone cross it, and I don't know a single person who sees. Even in 1940, the town conducted one study. The committee did not find commercial to be right of way. That finding still holds today. I respectfully ask CRMC to consider the evidence carefully and confirm that this property is not a public right of way. Thank you.
Thank you. Next is on my sign up sheet is a Brian O'Rourke, but there's not a designation that he wishes to speak. Is that correct?
Yes, it is.
Thank you. Glenn DeChico.
Good evening.
How are you?
Thank you.
with some
Good thing.
388 Shore Road. I live 50% further from the disputed unit we're talking about than the periphery of the fire district that we're talking about. So I'm pretty much just outside the periphery that we're talking about, like paying my taxes and whatever. And recently, I moved to Westerly in the end of the recessions. And we're about 5 districts in the law. Then as I moved around and continued to pay those taxes, and say, what really, we need to be excluded. So from the beach that's nearest to me, now, I mean, when I say thing, and then they're situation with a friend, unreasonable, I can see that head around fairness and that. Also, I'm going to talk about when they keep referring to the pro fencing as the reason nobody uses this, the reason is to be not that there used to be photos indicate from 40s that there were being that was sprayed around to the beach across Mr. Hoffman's land, just sprayed across. Well, he did take a cord on his circle but he's got a straight fence going through Spring Avenue. Which is private, but that doesn't mean the easement goes. Let's look historically, this photograph, so these fence, straight along that, with no fence pretty much. Now there are stronger evidence of fans that are out of the boardwalk, beautiful. And that might have been originally the wooden boardwalk, and now it's I don't know. Anyway, that has nothing to do with that. That has nothing to do with the spring easy. Now I got really recently that there was a concrete path around from the lookout to the lookout around to the illegal the same path. But which demonstrates lateral access that the real the public had lateral access, and they also had perpendicular access. I mean, the photograph speaks for itself, the plan speaks for itself, as to whether no one would argue that the town owns or the town shall maintain. But the reason no one needs to be noisy from waiting by and witness every usually that they have is because they want to go on. I don't know anybody else who might go out. And no one seems to answer. In fact, it's not even posted. The westernmost end of that fence is just well, we're not so good at the I don't know what year, and so that might be the moment. I think it was the unfair to make our walk to the beach and bike to the beach. It's crazy to have to walk the sand trucks and take left or right. And it's crazy, I live in the beach as well, but it should not be sequestered or reported to that beach. That's all.
Thank you. Richard Sherman.
My name is Richard Sherman. I reside at Fisherman Road, section Westerly. Fire district is station located on the side of the north side of the line. Is the owner of the Fisherman. I used this beach in the early 1950s, swimming, fishing, and directions.
And we might know that we realize that you're right. Undeveloped, environmentally sensitive area of beach. It has very fragile and conditioned use. I think the storm marshes. And notice a wide variety of shoreline land. The issue of whether a open land debate exists, so-called spring episodes. Legal issue. This is also fundamentally important. The efforts of the defining body which constitution represent the vast majority of influence. Limited and restricted public access to the beach has been allowed and managed for many years. Fishing and producing. But should unrestricted, uncontrolled public access to the spring end extension be left? The goal result will level of human traffic that will have a materially adverse effect on this very fragile area of beach. Such unrestricted public access will surely result in inevitable environmental destruction.
Thank you. Michael Lombardi. Good evening.
I am very easy to do what it is, and I'm really. And I feel like children, sort of, that these things which was built. Also saying, he's been getting by anyone. Once he really got getting, kind of went to the conference, so there's no way it can be a thing. So that's something that should be made with. Once it was recognized as a leader, the town of Westerly came on. Let's see, Constitution doesn't also say that we access the shore when it's good for the people of land. Says we access the shore. We go there to fish, we swim from shore, we do feed out the city. And basically, Article 1, Section 17 states that people shall continue to enjoy the free exercise of all rights, fishery, privileges of the shore. The town shall Westerly state shall come to the bend. Very quick. As I'm moving this down, it's my understanding, the sand road was actually controlled by the town. So I don't know how the town, like that's the part of the control, but that should be kind of weird. Springfield convention went away, blind people, their constitutionally protected access, without access, maybe you can afford forward or wide, you get off the 10 road, or rails, walk down the 10 road. There are access to that 2 miles of beach. That's really big. City guarantee and the town of Honolulu supported that opinion, and it's up to the current town council. If you ever need a power, make sure those rates are done. When farmers give us those protections, also provide we have fishing swimming from shore, we got the city that will be carrying on here. So it has to be a reasonable point of access, because if it's too long to go, the carriers that need to engage in our activities, it's not the access. So it's gotta be equal access. And the still around, eminent domain was 4264 all that strong, subsection 45, 50, 13. Allows for eminent domain to the municipal park. Right now, it's and I'm not in favor of, pushing this, but, they're giving the trip with our rights. And maybe we need more of those spots down there. Maybe we need yeah, so we basically double 50 spots, and then use our town council passes for the rest of the spots. And basically, didn't move down here, wanted to come down here for 2 years. It wasn't my point to be up here arguing this, but it's kind of like, don't try. I mean, like it is, recognize that it is right away. Yes, it's sure. And it's unfortunate that, basically, they've been so fortunate in life to have this. And here they are trying to basically keep that access to the rest of us. It's in our constitution, it's in the town charter. We should be protected by this. And the town should. Also, go down there and try to ask somebody, very misleading. They said, I'm going down here, I don't want to step on your toes, but I want to make sure, my right to access is really locked, but it seems like it's very, very hard to figure out what is going on in that. And, well, basically, that's pretty much all I have to say, and I hope you would, do that.
Thank you, sir. Bill Pike, do you wish to speak? Okay. I've got a second page, and it's a full page, but not everyone designated that they wish to speak. So just to speed things along, I'm gonna call the names that are here. If you wish to speak, just say yes. If you don't wish to speak, just say no. I'm just gonna go down this list quick, and then we'll call the people that wish to speak. Steve Banahan? Yes. All right. Jim Tarbox? Yes. Ellen Kane? Marianne Dalmazzi? Am I saying it right? There's a Michael and a Marianne Dalmazzi. I'll take that as a no because it's not indicated. Karen Engerhart. Martin Green. So Martin Green wish to speak? Tom, looks like an M-I-C-E, okay. Brian Elson? Yes. Dana Wells? Okay, got a Nick. Paula Fillion? John Hamill? Read it right. Doesn't know, it looks like a no. Heidi Costa? Michael Chamberlain? All right, so let's go with the ones that wish to. Steve, I'm sorry, I can't read the last name. It looks like B.A. That's you. Oh, yeah, come on.
Hi, good evening.
How are you?
My name is Steve Barrington, with 2 Oxford Street, Westerly. For renovations. In the 50 years that our family owned the house, we have consistently between each aspect. There are currently 3 zones we are in the. The current cost. They house in front of them, they don't want to open up. We've also seen access to the beach. And yes, we can all be at certain times. But if that wasn't one, I would do that now on a regular basis. I have only 1.1 miles away. So to say that you're not using it, therefore it doesn't exist anymore. Not going to like the 50, 70, the black girl, all the way down to 20. I have been asked to leave that beach. And I have been asked to deny access to it. Both of them. It shouldn't matter how much money you have. All people in Rhode Island should have access to the beach. And I think it's here on the obligation to be sure that no one right of the way, open and be. Anything less is certainly.
Thank you. Jim Tarbox.
Appreciate the CRMC members that are here tonight. I respect the vision of this and this. One of the things I didn't prepare, I have to move on to some arguments made because that particular way of way is not maintained. It's not right. Arguing with our town officials, please maintain the regulation because we know anyway, my earliest recollections from Adam's mention was 40+ years ago. I had the privilege to fish as a young to learn from some of the sarcastic old timers. When at that time, we were probably around the age of so I no longer consider that a good timer. Gentlemen on the counter and people above and spoke of Canadian access and Spring Avenue widening the younger which is strike. They also told me stories of using Spring Avenue as children who access the beach with their parents and grandparents and lighting. Remember whitefish and wash up in the winter time in bushel baskets, and the ladies will often collect the seeds and dress their gardens. Doesn't have to be. So according to the people testimony we heard tonight, he's incredibly fine gentleman who lying to me. I just don't see that in the case. Pretty much character. And these same people told me if at that time, 40 some years ago, younger people didn't start paying attention, taking action, all of the public's access to the show would be taken away by the wealthy. And how right they were. Fortunately, we were tasked with helping us go forward. When public interest in action resurfaced in the mid-90s, and so many of the photos and maps that eventually submitted to the public to you as CRMC, clearly showing certain avenues used by the public going back a century to access the shore. And I'm certain that the photos that I saw of horse-drawn carts using the Spring Avenue access were not being used by the residents of the whole county of people, but rather common folks who worked hard for their existence and got to see fertilizer, something they learned from the indigenous people long before. Included in the enormous file of evidence provided to you by the public is a letter from the Attorney General, expressing his support for affirmation designation of Spring Avenue based on clear evidence dating back as far as 1886. So these arguments seem to be coming from 1944. He also references a long history of public use supported by photos and other evidence. Very simply, Attorney General agreed that the standard of substantial evidence had been met, and I believe it's important for the public and the press here in the Lewis tonight to know that the recognized definition of substantial evidence is more than a scintilla, but less than a preponderance. I believe we're pretty close to the preponderance on this. And I would, if you're going to take, I'd like to submit 5 CRMC designated rights of way that were found to meet the standard of substantial evidence. In light of the fact that significant evidence has been provided for Spring Avenue, I asked the CRMC to be sure to apply that same standard that you did on these 5 when making this decision on Spring Avenue. Thank you.
Thank you. Lynn Keane.
Good evening, my name is Ellen Kane, I'm 76 in Road in the city. I'd like to thank the Commission for stating that the public will have other options or opportunities to speak, because certainly without having had the ability to hear the words to make their presentations, they would be disadvantaged. So I'm very glad to hear that without making it clear for everyone. I'd also like to follow up on what Mr. Talbot said about substantial evidence. Partly because I think that's what you would make your decisions based on, as we have on other rights of ways, and also for members of the public to really understand a bit more about what constitutes evidence for this. And the fact that said that substantial evidence has been defined as more than scintilla, but less than a preponderance. Scintilla would be like a shred, a trace, a smidgen. So not much, anything more than that falls in this guideline. And preponderance has been defined as more likely to be true than not. Which brings back to sort of the aid of the Patriots and the balls to play more likely than not. Actually, don't even need to meet that bar, it's less than that. So the sweet spot is more than a scintilla, so it's substantive, but also it's not like what we watch on TV and it has to be beyond a shadow of a doubt or anything. So I hope that will help people at home who may know that their uncle used to go there, maybe they have something substantive to say for your consideration, and hopefully encourage you to participate. Thanks very much.
Thank you. Mrs. Thomas, is it Westerly?
Thomas Westerly, 42 Monmouth Road, Westerly, Rhode Island. I just want to thank you all for listening to the public and hopefully doing the right thing. I also have been asked to leave the beach there when I was fishing, and I've also been blocked from access more than once for both. I've seen some of the pictures, I've seen some of the evidence, but there's a lot of people who have a lot of that you've got and you've seen. I just want to say that I'm for access. The environment has been brought up a few times by a couple of the meter box speakers that fear that us common folk walking the beach may damage the environment. The fact is, I used to teach undergrad, and the younger person goes to nature, either the beach or the forest, the more likely they are to respect it for their whole lives and times, you know, you go to state beach, you go to town beach, you sit on a beach, you go swimming, that's wonderful. But you don't get to go and see a real natural beach. We have to swim with Westerly. The Westerly beach area, 1.8 miles of beautiful pristine beach that some people probably like to bring their children to show them what nature really is about, not the beach where people lay there covered with sun sandwich, which is wonderful, but it's very different. You don't learn to protect the beach by being at Westerly Beach. But Westerly Beach and Apple Point, both of them, public access is very restricted. As you know, they put up a fence. Nobody knows to put the fence up. I remember hearing quite a bit of discussion about that. Oh, there's never been a permit. Somebody just put it up in the dark night. And sadly, the town councils and town managers in Westerly, many of them wonderful human beings, but they have a history of allowing accesses to fall into disrepair and to be taken over in backroom deals. And I know some people don't want to be saying that, but that's how it is. The last thing I want to say is I pay taxes, and I paid federal income tax since I was 16 years old. Some of my tax money goes to subsidize flood insurance for the people who don't want me to walk on the beach. And also paid to raise many houses with grants from the federal government to live in homes. So I think it's inherently unfair that the people that ask me, who has a lot less money than them, to support the flood insurance and to support raising some of their homes, yet they don't want me to walk on the beach. And why do you think about that when you're making this decision, looking at the amount of evidence that shows that that was the right way? One other thing, I don't remember anything from when I was 5 years old. The last majority of people said, oh, when I was 5, there was no access. They were told to say that, or maybe somebody else told them that, oh yeah, when we were kids, there was no access. I can't imagine a 5-year-old remembering there was no access to the beach. Please take that into consideration.
Brian Ellison? Did Brian respond? Here he comes. Good evening.
Good evening. Brian Ellison, President of Westerly, Rhode Island. I wasn't at that meeting, but I've been inspired by fellow citizens, so I don't really have well-prepared remarks, but just so I've been a Westerly resident since 2007, I believe. I don't have as much historical context as a lot of the other folks that have lived here their whole lives. I learned about the access issues down in the pod. I don't know, a few years probably before pandemic started playing. I really liked it. That's what I did as a kid growing up in strange, moving far away. I was disappointed that I didn't get to the product. I started looking at people, and that's fun. Because you can't put public access on town Westerly. So I started doing some research about the GIS town websites and found out it's all private. So research, my own research, photos, you can see clear as day when there's a path that goes posted a lot of your research and that it's like, oh, since there's not sign, I struggle with, buttons and fences. They're not good fences, right? Just because you put a fence up, of course, someone can use the fact that there's a fence there that's blocking. I also take a little bit of objection to the conservation argument that is in the beautiful area that people with a lot of time and effort to preserve that area. And now is probably say, it's my most happy place that I've ever go to, and absolutely love being there. I don't think anyone here had meeting access, the overrun, and moving at the beach, really to Swan Lake. Just don't want to fire district. Even as a gatekeepers, all the access that they give access to the beach. Regarding all that conservation area, again, all the access records go on the GIS website. A lot of taxes paid on the conservation area, which to me is a little puzzling. If it's concerned, is it concerned for me or just the folks that live there? If it's concerned, but I can access it as a taxpayer, right? I can do it taxes on the land that I own. So if other land is getting a tax break, but I can only access it at the discretion of the people who don't want it to be about conservation. I don't know, I'm not a lawyer, I'm not a tax lawyer, I'm not a property lawyer. I think the town would see, look at that, this ends up being an access to the tax records, I'm not the same thing.
Nick Silico?
Meeting, myself would be here way after much for that. First and foremost, I support private property, public property. It's all about what the evidences and what the evidence is telling me. And from my perspective, what I'm seeing from legally is actually is very clear that town of Westerly owns that right of way. And I'm asking CRMC to reestablish previously town right of way. First and foremost, just to keep very specific to discussion, there's a statute in 1920 that gave procedure to the dedication of roads and staff. As 1939, 1941, and 1948, or like that, the procedure was essentially, there had to be essentially a stamp or endorsement approval, physical endorsement approval on flat maps of the town land records. 1939, 1941, 1948, there are 3 different endorsements from the zoning board, Washington zoning board, the highway commission, and the town board endorsing Spring Avenue as a road. I also want to point out that proponents of this right of way, public right of way, have indicated that there's already 90% of the year the public has access to their walk right of way. That's a permissive right that can be pulled back at any time by the priority. It's not guaranteed. The thing I want to point out is right at the entrance of the extension, at least a dozen parking spots, and you can't find any other public parking spots. You can't find any other public parking spots. East to the west, just so happens to be right at the entrance to the Spring Avenue extension. So I'm just going to let that one marinate in mind around that. I would also have to say 15 public parking spots are going to break the campus back and cause a traffic jam. And we already have people going in, but the outflow, there's already a great deal of traffic and so on. So I can say 15 parking spots is not going to create additional traffic. Just a reaction to the lifelong resident of this town, commercial fishermen, recreation fishermen, and like I said, I'm all about supporting what the evidence shows for the property rights. If the evidence shows that fronting the neighbor's property, the evidence shows that property rights, private property rights on the upheld, I support that. It shows the public, I support that. What I've seen so far, the evidence supports that this is a public and we're here to ask this community to reestablish what was already there. Thank you.
Thank you. Robert Goulet? No? And Thomas?
Thank you.
How are you?
My name is Ann Thomas. I have to proceed through John Farmer. My family has lived in John Farmer since 1915. I grew up there. I've been going to the beach in my youth. In fact, I was sailing with Mr. Wayman when we were kids and young. I'm very conflicted about this right away because I firmly believe the public should have free access to this incredibly pristine beach. But I also recognize that there is private ownership issues, and I don't think it's appropriate for the CRMC to take land that is not owned. So as I say, I've been going to the 20-year beach from the area. And as far back as I can remember, since the early 1960s, Westerly has always restricted access to prostitutes to get to the beach. In fact, even I, as a Shelter Harbor resident, was not allowed to walk onto the beach. I had to walk down the sand trail to get to the Shelter Harbor beach to get on the beach. And that goes back to when I was 5 years old. It's very possible that there was a second path. I have no other than, and maybe there wasn't out there in the 1940s. But I will also point out that there is an Oregon law that extinguishes easements and rights of way that are not referenced in deeds within the last 4 years. This is in Rhode Island's Marketable Record Title Act passed in 2005, Chapter 3, Article 13, Sentences 1 through 4. It basically says, if there has been no mention in the deeds of this being an easement or a right of way or some other type of transaction, then it is expunged. And the claims of interest are divested from it. Nonetheless, Barrier Beach is an incredibly beautiful beach, and I really want to have access to this beach. The first tiny portion of this beach, at the western end, is the Youth Club in beach and open space, the Shelter Harbor Beach, and the Shade Beach. There is in fact a path that goes to that empty beach between the Youth Club Beach and the Shelter Harbor Beach. And it would be really wonderful if we did not put a guard in that second path and just let people go. Because that's what it was not very long ago. 10 years ago, people had free access to walk to that portion of the beach. Now, I'll point out, we Shady Harbor, Shelter Harbor, pay a lot of money for the guards on those beaches between 9:30 and 5 every day. And it's still for the public to come in and say, oh, I'm going to sit on this beach and have this guard taking advantage of the beach. So I really love to see, we might actually use the second access on the beach, between the two beaches. And like Mr. Chairman, I'm a little bit concerned about opening up yet another pathway to the beach, which gets washed out every time there's a major storm. Last winter, we had to spend quite a bit of money moving sand out the road, the parking lots, because whenever there's a big storm, sand washes over the paths, and lots and lots of stuff goes into the road and into the parking lots. If we cut another one at this point, which is supposed spring avenue extension, where you have to now deal with water and sand washing over there. So if we do put it into the right way, I suggest that we actually build a and the bridge goes up over the dune rather than coming through the dunes. Currently, the one that can get to the beach, they can walk up the sand trail. Generally, walk pretty far to get to a point, if you can pass the Shade River Beach and go a little bit further, and then you'll find the breaks in the sand dunes, which was caused by the storms which washed through and broken the dunes down. So we can get there. People also drive up everything and over Sand Pass, because there's no parking at the beach unless they cross the dune crest and then drive on the beach at pace, which of course would be illegal based on their regulations and driving on the beaches. I'm very concerned about that flooring, the Charleston end of the beach, because the sand dunes there were very badly by the standing.
Thank you. Jed Thorpe.
Thank you, Mr. Chairman, members of the committee. Judge Thorpe, I'm the director of advocacy at Safe Bay. There's probably nobody here in the room who cares more about ecology and the health of the shoreline than me. And we strongly support the designation of this right as a beach. The arguments that we need to keep people off the beach and protect the beach, frankly, is somewhat ludicrous to me. And so we are strongly we submitted written comments in support as well. We want this to be right away, public right away. Frankly, it doesn't really matter, but we want it doesn't matter, frankly, like the public wants. What matters is what does the evidence show. And the important question that before CRMC, which is number one, was there an intent to dedicate Surrey extension as public right? And number two, was it accepted as a public? On those two questions, we believe that the evidence has been presented as a very clear yes, both of them. It doesn't matter what your neighborhood scope is, it doesn't matter what legal theories are out there. What matters is what is in the official land evidence records. And those records I may show that the intent is there. Even if you go back and look at maps from 1920, 1939, those maps were clear back in the same time that the intent was there. And the acceptance could be through either public use or by official action by the town. We believe that straight out extension was accepted as a public right of way with both of those two criteria for acceptance. I heard a lot of pronouncements tonight about this or that has never happened. I think it's always been this way. Time did not begin when we were all born. There was a lot of time before perhaps our memories where this extension was most certainly used by all. Just because the two
Dan King. How are you doing, Cindy? You okay? Yeah, you okay?
Good evening, thank you for having back to that long trip, so for me. My name is Dan Kane, speaking on mechanical, so I used to like 75, over 75. In addition, I'm also going to most of my education, but I don't speak for them this evening. I am in favor of constraint right away. Like I mentioned, I did some 20 over North Colorado. I'll leave the results of all the research to lawyers hash out from you. Upcoming meetings. My concern is that the existence of this spring up right away or the threat of this nuisance is the only reason that is any public access to the speech. Several people comment that I was open to the public access here. I have been around for access many times, and it's just been a huge. The rules are written by the PCC and go to the public, but that's not my happening. If I do find it open, and September 15th, today, so it will be open to the June. But during the summer, it's really spotty, it was open, really open, so. My concern is without the threat of this right away or the existence of the right away, there's no longer any incentive for the fire district to grant public access at all. A few years ago, I saw a brochure published by the Westerly marketing exclusive private eco-tours of the private exclusive peninsula. What we're talking about access to it. And I wonder what this fire district motivates in fighting codification of sort of life. If it isn't simple, just something to consider. The other thing that's striking to see is we heard a lot of comments from people opposed to this right away from the department. Saying the public has access to the beach or the Weed Park Fire District boardwalk for many years over and over again. That strikes me as absurd. Easily. 100 feet from what we're talking about. Personally, what does it matter whether the right of way is here or 100 feet to the east? The public has the right to access that beach. What we find that to be true. Thank you.
Thank you. Matthew Ferraro. How are you?
Resident at 65 Market Street. My background here, the reason I'm here, because I gave a position at the Weed Park Fire District on January 22nd this year. I was told to get a lawyer, recommended to get a lawyer, so I spent time within the Harbor District Plan, reviewed a lot of stuff that I've spoken about at conference meetings here. And essentially, I wanted to share some of those key moments from that deposition. And one is the use of the concept of property assistance. I used it in
I'm here to refute the first three apologize and say that path wasn't used. I used to do a survey, a server here in Rhode Island, since 1973, Westerly, that's travel. I don't travel to serve, I stay at Career Coast Guard 22 years. And now I get to talk about my Coast Guard career later as I go into the public management. But one of the other things was that I actually pulled up a photo and have that photo designated service spot as according to the town bylaws to the line break, and we're allowed to serve in that spot because there's no lifeguards, because it's available to serve 24 hours a day. Public beaches are closed off, and lifeguard beaches are technically closed to serving due to the town bylaws. So I brought up the existence of the search spot. But the most important thing I did was bring up the testimony of Catherine Burke. She testified about fire street a year earlier. Her testimony was January 30th, January 11th, 2024, 10:03 a.m. And specifically referencing Subcommittee goes away, not a certain outbreak for 20-11-84. And the reason why I bring up Catherine Burke's deposition is because it exists within my deposition as an excerpt. And I feel like I can share this with you, even though I don't own the rights to my own transcript. I was able to get my transcript, but I'm using Kathleen Gray's transcript, which was Exhibit E, page 87. Conversation goes as follows. Okay, could you please explain how and when and why whom you came here for your spring out extension? Kathleen replied, I was visiting my friend in high school, Liz Weston. She invited our other friend, Matt Barrow, we were just hanging out, catching up. He asked me if I remember the past, right into the taxation beach.
I'm sorry, you have to speak up.
Okay. Something about that. This Catholics or someone. And I said, yes. He was very happy about that. And he asked about a talking attorney. We got to me about it, and I said, oh, really, this is Catholic. So we talked about it a little more, and then I thought about it, and I said, well, I do remember it, and I discussed it with you, some distinct memories. And I just said, okay, all right, it's true. So Kathy described running down that path. Kathy was a track star throughout her high school career. She described her dedication. She called me right out. She was saying that. I remember it because I raised my brother. He ran down the bottom pathway, right pathway. I ran down the other pathway. That's the right way she ran down. So I am refuting members of the Green Park Fires telling us that, yeah, you didn't use that right away. Kathy raced her brother, she won the race. And it was quite a scary conversation. And so with that, I would also bring up that we now Hoffman property came up within these excerpts. And my deposition was over 2 hours. I thought I had it pretty well. But when it came to Green Park Fire District's lawyer handing me aerial photos from 1974 saying, you recognize the path? I said, I'm not going to do that. That was insulting to me for many reasons. One is that it was the current photo compared to, and the other was that it preceded my time. As I said, I used that path specifically on one occasion in 1980. I was describing that being a young adult, being led to this search farm
on the floor. This is all like a whole story, but now we're using that path, it's so big. They have to share it. That's what brought me to this. Many hours in preparing for and giving that position. And then follow up was a completely different. I would have to pay $590. And sure enough, I would. But I am sharing the parts of my testimony that are classified as exhibits. And I want you to have them. I want you to look at them. I want you to take the time to have and ask them why does not property survey current Hoffman property to compare their reconstruction of their house, which expanded into the west. We didn't take extra long with that. The town owes you a survey of where that property is. That's what I did. Here's the photo of exhibit 4. That's the record.
Can you give it to them?
Record. Another part of that was, a year ago in October, I went to CRMC. I was running the state with Superior Court with the side of the essentially, the far side of the way we said, I gave this person a map and he couldn't identify it right away. I believe that he was disingenuous because it wasn't that I couldn't, it just wasn't doing that particular task for him. I believe it's a job. The public works director, the town manager, town council will determine where their right of way is not needed in the public deposition. When he testified in front of you, he was being disingenuous. I didn't get a chance to speak of that, but I certainly was insulted by it. There's one of 2 very photos. Here's the second one, photo. It's 1974. That was 1960. So, Kravak coalition. Again, I wouldn't identify off of this record in 1974. Just wasn't going to happen. I mentioned that the federal government is in place. And been involved in about 4 years. I Coast Guard back the science division. And during my direction, a number of years before, for projects around. And I don't know, 4 years and 6 years, I actually certified. So 20 years ago, a lot of work was Coast Guard. I read through your guidelines for the development of this power grid. It's not true. And part of the reason why my testimony was broken, I felt like I should testify. I just said, no, I don't want to be involved. Because case 20. Case 20 describes New York guidance under the required elements of power management.
Public access is a general term used to describe the way the public legally reaches, enjoys, coastline areas and shoreline in the state which the public must trust. Public access includes physical access, visual access, interpretive access, and it's right in the plan. So Kathy and I were testifying to the physical access of the right of way. The ability to reach shoreline football areas by appropriate vehicular access points such as the right of way, coastal launching lanes, and fishing piers, and the ability to pass and repass horizontally along the shoreline as guaranteed by the Rhode Island Constitution. So yeah, I was in Penn for 4 years in a planning office. So then I returned to Providence in 2010. Spent another 2 years and worked in planning. And so I did my due diligence of reading through the guidelines. Very impressed with wrong. Because everything in here, as written, is pertinent to the shoreline of Western Rhode Island. And I read Westerly's first draft, that revised in 2018, and I compared it to the guidelines. And so I read it once, and then I kind of made those. Then I got involved again in 2015 with another issue, and I read the harbor action plan, and it kind of convoluted. Your guidelines say that you have to designate who is responsible. In the current harbor management plan, I don't even know if it's approved last year. It exists in the comprehensive plan. But I don't know, never got proper approval from anybody. So it is a great time to go back and look at Westerly's harbor management plan. How it's managed. I don't think it's being managed properly. There's a section in our harbor management plan, the Westerly's harbor management plan, and I would cite pages 45. There are 3 designated points of bay that we were talking about in the 16. I don't know why the original drafters would write this right away into the plan. It never actually existed. They didn't recognize it in the first draft, and it's still maintained currently in the comprehensive draft. So, with that said, I will offer you sort of the license. Which definitely shows why I'm concerned. Because you're blocking permitting access to surgery. And this is a popular activity. It's in the plan, right on basis. That's my evidence that there's stop that against you and be a lot. And I kind of like back and forth with Mr. Fireside, the lawyer for people law. And he didn't want to call it the state agency, so he might call it. That's the spot, the spot. And I said, we call it, I don't want to call it because it's right, since '80. And I think I'm speaking on behalf of a certain segment of these users. And I hope you thoroughly illustrating the resource management council, studying and oversee this right away. Do due diligence, keep an eye on how Westerly. What shenanigans going on. I don't think they're managing the harbor management plan the way they should. Thank you very much.
Thank you. Ben Weber.
However, they lost support was the way around. And the chair of the Westerly Management Commission, but I'm here speaking on their behalf. Okay. For those of you who may not know me, let's remind that 2020, was certainly was me. I was a thorn in his side. I stand before you as the only person in the last 40 years that I know of, to the best of my knowledge, as God be right away open in this community. Wasn't doing it. He started to reach out. We had to do it. But because of me. It cost absolutely no money. It was no lawsuit. Fortunately, this is the norm. It was against the very same people we're talking about right now. Why did that happen? Because you heard my mother, who sat there and spoke earlier. Mrs. Weber. I was trying to take my father, Mr. Weber, who taught me how to fish at Ridge Right, and my grandfather. And she also testified that her family goes back 7 generations. Fishing in 2020 from the state parking lot, the fishing access parking lot, using a century-old path that we used to get to the end of the Ridge Right. We were blocked, and I was threatened. And my father was in the car that was just before he was going to have his second heart valve replacement surgery. He's now had 3 who couldn't make it tonight. And I want to thank my mother for coming out and speaking. She had to leave so she could go take care of him. We parked in the handicap parking spot there. That's designated as a handicap parking spot. We attempted to access the centuries-old path. We were told we couldn't, that we had to walk down the entire length of the jetty on the rocks, full of poison ivy, to access it. So I'm going to ask you the same question that I asked them, and then I'll tell you their response. How does somebody in a wheelchair walk down an entire jetty of rocks to access a fishing spot? I think we all know the answer, but their response was, I guess this is the beach for that. So, that kid that told me that didn't know the ramifications of what he was saying. He was told to say that. So I took it upon myself to walk through anyway. And I was physically and verbally threatened numerous times, of which I hope recorded every single moment. Same thing down in Eagle, right where we're talking about. The sand trail, which by the way is state-owned property at the end, it has 2 express easements to get down there. However, I've had the police call on me. I attempted to drive down. I've been refused access to the boardwalk that I tried to use numerous times for fishing. Told that I have to walk all the way down the sand trail. Now again, I ask you, how does somebody in a wheelchair park in that handicap parking spot in public parking spaces and go down to the end of the sand trail to double back almost 2 miles to reach the cove to fish. I guess that I didn't reach for that either. I say before you because I've heard a lot of false claims of ownership of beaches. No beaches owned in Rhode Island. Certainly there's private property rights, but that's a flux border on the ocean. They all know that. You heard my wife's testimony earlier about family photographs. She also testified that there was never an issue. It was never an issue because the whole area was public. Is Immigrant Avenue. It was a paved road. It was maintained. That went out to the Old Inn in its original location. Everybody was welcome. Spring Avenue. You've all seen the plaques. Terminated at the ocean. Notice I said Spring Avenue. I've heard false claims of Spring Avenue extension. There's no such thing as Spring Avenue extension. Spring Avenue and Neighbor Ave were a 4-way intersection. The only thing needed an extension was them illegally locking it off with a fence. We heard claims that their boardwalk was the only right-of-way or opening to get to that beach. I've also heard the attorneys in subsequent meetings question photos, dates, whatever. I want to present into the record some photographs. I have them up and I would like you to see them. But this time, I don't want you to focus on just Spring Avenue as platted, which was wide open, a continuous road going to terminating at the ocean. I want you to look at the entire shoreline. I'm submitting these aerials to show you all 4 directions, north, east, west, and south. And if I may, I think you all should take a look at them. Can I pass them to the first person? You can pass them along. And we'll continue speaking. Is that okay?
Mr. Weber, so you can use them for descriptive purposes. However, they won't be entered as exhibits, but they can be displayed to the committee members.
Well, that's okay. Even if they're not entered as exhibits, you can find them in their own publication, the wonderful Westerly book. It's at the library. This is a blown-up photo. This is a blown-up photo. You've all heard the photo of the lady in white. The lady in white who's at the end. Who's at the end of Spring Avenue. This is a photo that's in the publication. Actually, I stand correct. No, yes, this is the photo. You see the photo in the publication, or it's another aerial, because the lady in the white, actually, there's about 4 different photos of her in different positions along that path, which is the path right next to the meeting house, which you can clearly see right there. Again, I'm submitting these photos so you guys can see all of this, that there are houses all along the shoreline. Here's where you plug in, there's the paved road, okay? Power lines, all paved and maintained by the town. That's the number F, down the center. That one was facing west. This one is looking east. Some photo of the bathhouses. There's the inn, the original location, more of the shoreline, down, all property. Houses on each lot. There's the old bathhouses in the corner. Spring Avenue is actually off the picture down here. Their boardwalk, or cement walk actually, from the bathhouses, leads right to it, in the other photo. Spring Avenue, 338. There it is, right next to the meeting house. Wide open. That one's facing north. This one is a later photo, aerial photo, because there was a question of if we're actually talking about Spring Avenue in the proper location. As part of our maps, Spring Avenue comes down from, this is 40s, late 40s, comes down from their new location and terminates right next to the meeting house. Here you can see the boardwalk going to the bathhouse. And you can see the remnants of Spring Avenue still left there to the public parking spots. What can be said for fact, my aunt in the family pictures was in front of the Westerly on its original location, and that was 1936. So if you look and pay attention to the background and the shoreline, the only right-of-way that was open for all was not the airport walk, because it didn't exist pre-38. It was Spring Avenue, was the only one open. Everyone used that one. Otherwise, they'd be trespassing on all private properties. Public, private, all use that one. If your dad, like I just told you, was a public road, it was paved, it was maintained, it was accepted. So you are telling me that the public going down on a public road, parking in public parking spots, using the only right-of-way that was available pre-38, even a little later. And somehow it's private. I highly doubt that. So again, I implore you, just because a town is derelict in their duties for maintaining something does not make it private. Just because a town gives away certain rights and roads illegally without abandonment, like the 1997 consent agreement of Linear Avenue, does not make it so. There's laws that need to be followed, and your job to follow the law and protect the public's rights to particular access, because this has been a long game for centuries. This is a game. Take away the rights away so you can't get to the shore to enjoy your constitutional rights. Thank you.
Anthony Palazzolo. After Anthony, I've got listed reading what, Gina Fuller? Is it Gina here? Okay. Is there anyone else after Anthony that wishes to speak that I may not have called already?
Sir, I only have 3 minutes to speak, and these people always take a lot longer. Perhaps I could have a few more minutes.
I think there's a list. I've been being told there's a list with 3 more people. I'm seeing some hands being raised over here. How are you doing, Cindy? After Anthony, maybe? Okay, thank you. I'm sorry, what? Yeah. Go ahead, please.
Okay, this is application first, original for allowance to submit documents and the constitution, so who do I submit them to?
Have the, Mr. Palazzolo, have these documents been submitted prior to tonight's meeting?
The answer is no to all of them.
Then they can't be submitted tonight. However, you can describe the exhibits or display them to the subcommittee.
And then subsequently, I submit them ready.
We'll make that determination at a later time.
Anthony Palazzolo was showing convicted. Police inspector Sloan dedicated in California to the non-free island. I don't have any clients with any interest in this matter. I can't, my license for Rhode Island. I've done a lot of shoreline access advocacy. I've been standing ones with not taking time for any of it. I undersold my capacity as a routine user of Spring Avenue. And I have some really great concerns with the way this case has been handled by the 3 opponents. As you all know, that there's 2 leading theories on why this is a Spring Avenue public right of way. I am a staunch advocate for the position that Spring Avenue was specifically dedicated around the common law and accepted by public users. I just as vehemently reject the position that there's a statutory limitation in this case. I'm really concerned that that second hearing, in fact, has been a major distraction and diversion of resources. It should have been used toward improving public user acceptance. And so the first thing I'm going to do tonight is to present you with some information that I think should be considered as you're presented with the theory of statutory dedication, and which essentially is acceptance by the municipality upon the submission of a plat map with 3 magic stamps. Put by the zoning board, put by the highway commission, and recognition by the code. Now, we also chapter 538, when it was effective starting in 1923 and the 70s. One problem with that theory is that it completely ignores section 5, which just raises and pretends that none of the requirements in there exist. In fact, it's important to understand that after the Commonwealth stage and before the President's planning development stage in reality of the law, there was a central period with a number of sister public laws, one of which was chapter 538. Before that, there was public law 1913, chapter 987, county province. 1914, chapter 1142, North Province. 1917, chapter 1597, Town of Warwick. 1915, chapter 1322, Town of Smithfield. 1917, chapter 1564, Town of Bristol. And of course, subsequently,
Westerly, the public law for the town of Westerly, chapter 538, which was back in 1923. So it was the last one of all of these sister laws. And the legislature had the opportunity to see the impact of the earlier laws for several years. Chapter 538 is essentially different than all of the other ones in that it adds section 4, and it adds section 5. And compare these laws, what you find out is all of the other ones operate essentially the way they went through the Pope's chapter 538. That is to say, you just stand for his own word, you just stand for how you machine, report that method, and really go out the requirements. That's it. The roads are open for public use, just like in the common law. We follow the map, we sell the lot, and then in city indications has occurred, so the public is welcome to use these roads. Section 5, chapter 538 is fundamentally different in that it added a whole new series of procedural requirements before a road under chapter 538 would be opened. Now, nobody has the ability to erase language from statute. So, the idea that we would ignore section 5 is absurd to begin with, but when we compare it with all the other sister laws, you clearly see that the chapters of chapter 538 put that in there for a reason. Damn good reason, it should be ignored. Now, as many as 3 years ago, I discussed this with my group, and I told them that this theory was at odds with a case called Snyder versus Westerly zoning board. Essentially waved his hands, said that's not relevant. That would be the case, that was about another subdivision regulation or law in Westerly, which was 2299, I believe. In fact, as almost every case ever comes down, there's multiple issues, there's multiple laws involved. It's true. Section 2299 was at play there, but it's because some of the lots were substandard, they were too small, and that was prohibited under 2299. The case was also relevant to, or specifically addressed, chapter 538, because the developer wanted to have his subdivision approved by the zoning board and the highway commission, and then so that he could then record it even before he met some of the other section 5 requirements, in particular that a road profile be submitted. And essentially, the zoning board initially took a position not dissimilar to my group. It said, well, no, you have to comply with all the road requirements in the statute because chapter 538 is a one and done type of event. You have to do everything, and then you leave a stamp, and then you record it, and you all know everything's done. The moment you record it. Well, that was the point, said something the way it works. The requirements of section 5 are applicable, but they don't all have to be done right up front. They ordered the zoning board to give the guy his zoning board and highway commission stamp so he's not going to be recorded. But they still require him to come back later and file his road profile. Now, my group says the Supreme Court erred when they wrote anything about chapter 538. They expressly discussed it in there, and he thinks that they're shit on it. They put it in there as a mistake. So I got copies of the appellate brief, the petitioner, and responded. I have them for you. Guess what? They discuss chapter 538. So not only is it not the Supreme Court senile, apparently the litigants in that case are senile too, because they're all discussing chapter 538. When you read these appellate briefs, what you find out is the subdivision that was applicable in there was called Redwood Estates. There were 2 roads there, Round Hill Road and Montego Road. It was the recorded subdivision. After
after the Supreme Court ordered the zoning board to give the guy his stamp, he got his stamp. So he has three magic stamps. The zoning board, commission, and the clerk was recorded in 1964. Does that mean instant automatic acceptance? I'm according to the town of Westerly, because to this day, they list Round Hill Road and Montego Road in their list of private streets. Nobody said, oh, look, you got your three magic stamps, that's automatic acceptance, that's a public road. No, he said, to this day, that's not. 5, 6 years later, still a private road. So you have the Supreme Court, you have the litigants, you have the town of Westerly rejecting the three proponents, three magic stamps. So the only time this happened, obviously also in the town of Westerly, we have a development called Shelter Harbor. As we came Thomas' decision here earlier, I want to thank her, because she said something. Certain things, it's hard to try to love people, especially in a context like this, but I want to thank her for discrediting herself, because you aren't aware that she thinks she is, she studied to you, the Rhode Island Market Title Act, and said, oh, 40 years, hey, if there's nothing in the records about it, you lose it all. Apparently, Ann Thomas, though, the armchair attorney that she is, didn't think to read the end of that statute. I would recommend we have Mr. Harmon or Mr. DeCiccio take a look at that for you and see if the federal government, the state government, the municipalities expressly exempt from that statute. I think you're going to find she's discredited herself right here, right now. And I hope you take that into account when you listen to the rest of the testimony. I heard her talk a lot. She's on the wrong, although never a doubt. Anyway, getting back to Shelter Harbor, there were 3 subdivision plans, 1912, 1952, and 1962. By 62, the people in that subdivision had enough of the developer functioning around with plans to store them on some of their access. So they sued the developer until the Supreme Court was heard in 1987. The case was Samuel Narco. That case was primarily about the 62 development, but they did touch on both the trial court and the Rhode Island Supreme Court did touch on the 1912 development and more importantly the 1952 development. If you look at the 1952 development plan, it's right, in the time zone, chapter 538, and guess what? Has to be magic stamps. But if we would have believed that the town of Westerly accepted all the roads in that by hasten that inside, I promise you this, I sure wish that's true. Because there is no recognized public access to the Time Warner's Water Control Colony in the town of Westerly. But in Shelter Harbor, there are 6 roadways that terminate the Time Warner's of the state. If Michael Hood is correct, that's 6 instant ways where we have none. One of them is 100 feet wide. It's absurd levels of parking. It's a shoreline access advocates to let's see what the Rhode Island Supreme Court had to say about that. The trial justice found that all the 1912 and 1952 plats had never been fully accepted by the town of Westerly. Trial judge disagrees with me. The 52 plat had never been fully accepted by the town of Westerly, even though it had 3 magic stamps. The violation of the 2 plats resulted in the city dedication of Shebert Road. Around 10 Park continued on. This court has long held that when a plat is recorded, which speaks to really data on the lots of show by reference to the plat, there is a civic dedication of such streets to bring to the public. They didn't say it was an instantaneous acceptance. That's true Supreme Courts now have looked at
subdivision plats on chapter 538 and found that Michael Rubin was wrong. We have done with a whole other host of characters who have consistently rejected Michael Rubin's theory. They include the Rhode Supreme Court, the United States Supreme Court, Rhode Island Superior Court, the CRMC, and Michael Rubin himself. Because there's a subdivision in the town of Westerly called Short Gardens Road. That was recorded in 1960 within the chapter 538 time zone. There's a green magic stance on that plat now. My father sued the CRMC alleging that the regulations the CRMC took his property without just compensation. Michael Rubin litigated that case all the way to the United States Supreme Court, and that has happened for years. I am not exaggerating when I'm saying 20 years. Here's the copy that I have. The magic stance on it. I wish I could hand it as exhibits, which are prohibiting me from doing so. Now, why is that relevant? If Michael Rubin's theory in that case was that there was no reasonable investment-backed expectations for that development, so there was no taking. Why was that? Because 6 of the 18 acres were roadways that were between Monkey Peak. He and his experts said it would be so absurdly expensive to build in his name and bring it up to roadway specs that nobody could ever think about it. There's no damages, period. There's also no reasonable expectation, reasonable investment-backed expectations, because nobody would buy into such a stupid development with a private roads. Remember, he didn't say public. So he said there were private roads and the private developer could have spent his private money bringing those roads up to spec before Westerly would accept that. He did that on behalf of the CRMC while he was representing on the Rhode Island Attorney General's office. 20 years, he said they told everybody he could. There's no taking here because those are private roads. It's unfathomable to me that the Weed Fire District is not going to claim a stop here. You heard earlier, accurately, from Jim Tarbox and others, on factual matters, you get extreme deference. The statute says that you can find the right way as long as there's substantial evidence. And that means everything more than a scintilla. And I'm taking the extreme efforts from these courts. That is not true on legal matters, on legal questions like his theory. You accept his theory, that's going to be reversed. And even more resources are going to be squandered on this misconceived effort.
Jeff, see what's me 31 minutes.
What about the town of Westerly? We're not doing that. We're not doing that. Let's just talk about how for, I guess it was starting in 1964, Westerly adopted the Rhode Island Supreme Court's position, so that's been 55 years that they rejected that theory. But it came up again in 1986 when my father, had a subdivision through magic stamps. But that was essentially all constituted by two Monkey Peak. I had the audacity to go to the then solicitor at the town of Westerly, Jacob Anthony, and he asked them to please file Short Gardens Road. It was the one road with some dirt on that. And it resulted in this letter here from Jacob Anthony. And what he basically said, I'd like to give it to you if you won't allow me to submit these minutes.
Mr. Palazzolo, what I'll say is that under section 1.59 of our management procedures, you have to submit these exhibits 7 days in advance.
Well, I'm thinking that, we had a Western County Management Commission that begged you guys
guys to tell us how we were going to handle these procedures since April for reasons like this. I printed out 6 identical copies of all, for every single thing I'm talking about, and Mike Rubin said that we'd be able to pass them out, and all have copies and follow along. So regardless of how it happened, I can't submit any of these things, I can merely describe it. You'll have to forgive me if it takes more than 3 minutes in total.
I'm gonna ask you just to finish up a little within the next couple minutes.
Okay, Jay Lopez told my father that, they don't, the town of Westerly was maintaining roads under the old rule, that's chapter 538, so they're going up to spec. And these roads obviously weren't going up to spec, so the town's not going to maintain them because they haven't accepted them. And, just about the last thing my father did before he died was to file a lawsuit against the black-hearted trespasser who tried to take some of Jordan Gardens Road. His name was David Champion. In response, David Champion filed a third-party complaint against the town of Westerly, claiming that he didn't trespass on anything because Jordan Gardens Road was a public road. It was accepted by the town of Westerly. The town of Westerly litigated that case for about 4 years, and they vehemently rejected the notion that they accepted Short Gardens Road, even though it was depicted right here on the subdivision map with the 3 magic stamps. The litigant expressly asserted chapter 538. I would love to give you a copy of Westerly's motion for summary judgment, saying that they didn't own the road, but I can't do that. It goes on and on, all of this is why chapter 538 doesn't apply, and they did not accept the road. I think that's what I wanted, I didn't want anybody to steal my road. So I submitted them request for production documents that basically track chapter 538. Please show me a document that you were required to put in round corners. Show me the document that you approved round corners. Show all of these things that are listed. It came out of this. 42 request for production documents. There was a single document that is fulfilled there. None of those requirements were fulfilled. Naturally, the town didn't accept Short Gardens Road by 38, just like Westerly said. Of course, Short Gardens Road is on the private road list, as you would think, because it was never accepted.
I'm gonna give you 1 minute.
Okay. It's not going to say, it's still here, because I have no meeting, we'll have no opportunity to speak. If I can't wait to come back here and argue with even more force that there is enough evidence of acceptance by public user, but at least as early as 1921. That's where everybody should have been reference.
Thank you. We're gonna take a 5-minute break for the benefit of the stenographer, but just by show of hands, how many more people wish to speak this evening? I can't see them. You got 1, 2, 3, 4. I give Richard, I got you. All right, we're gonna take a 5-minute break. Deb, Kelly, Dominic? Oh. How are you?
And I'm president of Westerly, I guess I can say, based on what I've heard tonight, is that I am in support of that as a vote. But I must say, I'm confused. It's been a lot of different talk, on both sides. What I've seen more is I found to be, most important from what I heard from the testimony was the woman who was speaking about substantial evidence. So I think what I'd like to say just simply, I'm a little bit nervous because I was but I live in Westerly, I love Westerly, I love Montana, and I think we all can enjoy the beach in the city. I think that's why I want us to live here, because it's so beautiful. It's so energetic, I love the smell, I love the sound. So I think we'll just all get together and maybe take the morning, the plan, right? Let's just have one. You know, maybe this one or maybe that one. And I guess the bottom line, you know, for jurisdiction is to maybe we can just make the decision soon, so we don't have to keep on asking each other. I think it's ridiculous to live in the year 2025 and we can't go on. I'm not gonna like, you know, I'm picking down if they have money or if they have property. I don't like my taxes going to we will live on the dunes, because I believe the dunes should have been built on the first place. But I was up to shooting many years ago at the University of Massachusetts, and I did environmental science. I studied, it was a research assistant, Dr. Paul Godfrey, in the climate department, Dr. Stephen Lennon was in the geology department. We did research on Cape Cod Natural Feature. We had grants. We looked at overwater. We looked at dynamic stability. You know, there are real beaches in the coast as we have to maintain dynamic stability. If you keep on building on them or walking on them, it's going to destroy. We're not going to be having it. So I guess bottom line is, right now, I'm in support. I'm in support of the Rhode Island Constitution. The reason why I moved to Massachusetts to Rhode Island is because Connecticut was very limited. I didn't be in Connecticut. I've been coming down to Westerly since I was in my 20s. I love this area. I love all the people. And the opportunity to be solid together, make a decision, and move on. But please, at least allow one access point all to enjoy what the earth has to offer. Thank you.
Thank you. Dylan Costa. Dylan?
Good evening, everyone. Thanks to council for your attention. All evening I was on the planning board for a while, and the meetings got late, and it was really hard to keep your attention. Anyway, I live in Westerly, I live at 11 Home Street. Lucky for all of you, I had a testimony that was as long and as correct as the last guy, so thank you, but I'm going to condense it down again, so don't worry. I want to explain as quickly as I can why access in Rhode Island is an investment in the state, and investment in the county, and investment in the future. I'm not from Westerly, and I'm not living in Westerly 3 months from now. I'm working with the government in Oregon, and I'm moving back to Oregon. None of this, what I have to say, is selfish at all. It's all for the county. I grew up in New Jersey. My mom was a marine biologist, went to school for a job, geoscience, I had a master's degree in urban planning, and pretty much coastal geomorphology and studied with mostly in transportation. And my master's thesis was on the effects of Hurricane Sandy in New Jersey based off of different aggregate sets for different communities. And the communities that were wealthy could build shoreline stabilization. So the riprap, and downstream from those communities, in the less wealthy communities, was where every single barrier island washover from Caribbean City happened. That's similar to this because it's the effects of the wealthy having an effect on people who don't have the same sort of privilege. When I went to Rhode Island, the thing that impressed me the most was people's attention to and care for the marine environment. Growing up with my mom, especially working with her while she was educating students in Philadelphia, little kids in Philadelphia on the beach. Those students on the beach, learning about the environment, me learning about the environment, changed the path of our life. I've dedicated my entire life, 36 years old, and under 15 years in government, to protecting our marine resources. And that would not have happened if I didn't have access to public beaches, public rights of way, and the exposure to that education that my mom provided me when I was a little kid. Taking that away, or restricting access to that as a town, as a state, to all those individuals that go to the beach there, you're taking away the futures that are going to make the impact to your community down the line. This is going to go on now, and we can solve now. It's going to be the same fight that's going to happen 20 years from now. It's happening right now everywhere. It's here, it's happening in Florida, it's happening in Hawaii, it's happening in California, it's happening in Rhode Island. You all have the opportunity to take this flashpoint of coastal access and turn it into an example that can be followed, and you can change the culture, not just in your state, but across the country. And I really, really, really hope that you don't get local politics, local money, local influential people confused with your future and your children's future. Thank you.
Eddie Casella. Oh.
Good evening.
Good evening.
Thank you all for being here. My name is Eddie Casella, and I support Open Way. I didn't plan to speak here tonight, but I was inspired after hearing some of the other people come up, specifically those opposing it, saying this is for environmental concerns. I'm here to rebut any notion that this has to do with conservation. And I'm a wetland scientist with a background in mapping saltwater shelf, and geospatial analysis in the National Park Service, everywhere from Cape Cod all the way down to Virginia, and here in Rhode Island as well. And this past summer, for my connection to the master's program at URI, I had a chance to speak with every single board member of NICA. For those of you who don't know, that's the Oakland Conservation Association. It's made up of 20 residents, shelter residents, 20 residents. My first meeting with the trustees, they asked me about my thoughts regarding doing restoration and using volunteers to help in this work. As we talked about an idea that had biomimicry, which is essentially put, like, get these dudes back and being healthy. You use like small wooden planks essentially, and you put them in the ground to mimic native beach grass and roots, and then rebuild over time the dunes. And my idea there with volunteers was, this is such a hot-button issue of coastal access. There's people at pro conservation, and then coastal access, the big Venn diagram exists for all these people. Coastal access people are involved in also are pro conservation. And when I said that, the great idea was to be, let's go across the divide and bring in some of these people who are passionate on the topic and have them included in this plan, and volunteers work with the NICA. They scoffed at me and that vehemently disagreed, and they said that the only thing to do with quote coastal access. So in my conversations with them, they made it explicitly clear that they're not willing to raise any money necessary to hire a conservation manager to oversee this plan. And I got a verbal warning ahead of a follow-up meeting with them to not talk about coastal access at all, because there are crazy people on Facebook who they essentially will down to. So these conversations with people who are pro conservation, they're here saying, this is why we need to keep each speaking is a better reach, you know, the last remaining in the state in the northeast. You know, Florida and other things, you know, as underscored here today from other people, you know, environmental scientists, you know, and that it is necessary to have access to these places to see the beauty of these natural spaces, still will want desire to save it. And if organizations like 99 residents really care about saving this land, they would be employed. And use them as volunteers in this conservation plan that they have years ago. So, yeah.
Thanks. I think I've called on everyone that's indicated a desire to speak. Am I correct? Okay. Okay, you wish to speak? I come forward. Just identify yourself for the record.
My name is Mark, with the student management. However, I want the organization to own property on the plot. Also on the Charleston side, also listed. I'm here speaking on my own. I do not represent the organization I belong to. We are pro access. We've been out here a long time. Phone property has mine since I was about 8 acres and yours were all out this. I'm the River Beach. We walked back to 1971. Since then, it's been nothing but bad with the fire districts and whatever. Jeff was fire, I remember Post Road 2910. For that was filled up. The thing there, Post Road 2910 was 25 districts. It said no vehicles will park on the west side of Fox Drop Beach State Lane. That basically would give the public no right to be anywhere at all in that area. I rest of the area. Well, so I belong to Critters and Surfcasters, they all got together. It was a big deal for the meeting. We filled this place up here tonight. And like Vince, it was his name at the time. He said, please, no more emails. We heard you loud and fully. The other side of all this supposed evidence was not true, photos and things like that. And it was such an overwhelming outcry that was it. The CRMC said, no, we're not going to put this straight into effect. That had gone through. There we go. Public parking for fishing out there. I'm sitting in today. Another thing they pushed through was easement for the road consent judgment, which was illegally done. It was so illegally done, as town of Westerly actually changed your law, so you could never do that again. That piece of paper at the time was 97 consent judgment. This is worth what it's written on. Some stuff is totally illegal. Like I said, Westerly Town Council actually changed these rules. That could never happen again. So what I'm trying to get at here is these fire districts, you never ever stop fighting. If you don't do something, codify that right away. This will go back year after year. I've been fighting this fight since 1985. Going out there, I've been losing that boardwalk at night, go fishing. I started fishing in the early 80s before I joined the club down there, so out on my own. And the old timers were fishing out there, old stories. They used to drive on, and out was an open access. They put the fence blocked off. You can see them all the photos, all the maps, and all the things. You can see it all. It wasn't all overgrown back then. It wasn't good. They put the fence across. Fishermen used to cut it down and go out there, put another fence up, they cut it down. One time, some officers in, he said, I just got to cheap, but get out there. And then days were a lot of fish too. If you listen out of the water, pass. He used to put his old jeeps in first year 4-wheel drive, it would stay right in the sandwich. He walked out and he keeps along with the fish, casting, catching the fish, and the jeep would drive itself and steer itself. So I heard stories to those guys that they actually drove down to walk across that right away. They actually drove down there back in the day. So I know it's been a long time. I think we can guess it with the fence up there. It was not all vegetated. I never saw it open. know it was likely that it would start going down in the early eighties, but I personally have never seen the area. But if you don't do something to keep the public going out there, there will be no public whatsoever, access out there whatsoever. You know, that whole 1.9 mile there, which is beautiful, there's been sun there. In the back pond, showing everything nature. We just got a minnow trap, pull it out. When he was really young, put the minnows in your hand, put them into the water, it'll swim out of your hand. And just a few years ago, with my granddaughters, I saw them doing the same thing I thought. And it's a beautiful place for kids and family to go and bond and get out there like riding devices. And it really deserves to go open to the public. If you don't make it a permanent thing, it doesn't end it right away. We'll be back here year after year, after time. It's like we'll tires at home. People will never stop. Will never stop trying to make this private. Also, doing things. I hope that's beautiful.
Thank you.
Good evening, thank you for coming. Rose Over, I'm actually a town councilor here in West City, however, I'm not here at that capacity. I'm just here as a concerned citizen. I've been doing a lot of homework on a lot of different ways of getting educated, and I have 3 apps here. One is, they're all certified from the assessor's office. One was an app from 1940, the other was an app from 1980-ish. And the other one is from 2010, all showing Spring Avenue. Two of these maps, it does say Spring Avenue. And the map that I'm talking about is map number 169. There's no lot and lot. There's no lot and lot anymore. If this wasn't part of the road, why, if it's a private lot, where is the map that we have the map, the blockade lot number? There is none. And also, the assessor also gave a letter that said that the portion of the assessor map 169 identified as Spring Avenue is not a lot of record, and hence has no assessment history for the past 10 years. As such, there have been no tax payments on this property for the last 10 years. So if it's a private lot, who's going to pay the taxes on it? Because there haven't been any. And if you look at these maps, again, 3 of them from different times, all notarized and seems call it Spring Avenue and don't have a block or a level number. And that's all I have to say.
I just missed your name. I know you said you're a counselor, but I'm writing down names, so if I could.
Rose Van.
You spell it?
Van, like shutting in, VAN, and over. Please don't that position. I just didn't want to. Thanks.
Thank you. I believe that's everyone. Mr. Langseth, I know you had asked to speak, but I think you have something to say, right?
Yes, obviously I had very little time for meeting. I know this is going on very late, so I asked the council that the next meeting I can be a priority and have extra time.
That's fine. You're welcome. All right, if there's no one else to come forward this evening that's going to speak, well, Jeff, anything you want to say before we adjourn? No. Okay. I would entertain a motion to adjourn the public comment meeting. No. That's what I thought you were going to.
Thank you, Mr. Chair. Just before we adjourn, just want to let the audience know, and maybe if the subcommittee wants to take it up, what the future schedule for these hearings will be. I did mention at the top of the meeting that we will obviously have more. The public had a chance to speak tonight. We'll have a chance to speak after the attorneys make their cases at future meetings. But if you want to take up that discussion now, you can do it amongst yourselves, and I can put out to the public what that schedule will be. But I heard tonight, please make a decision soon. This is not something that will be spread out over many, many months, but we do need to be respectful of the subcommittee's schedules. They are volunteers. They have day jobs like we all do. So I want to be respectful of their time as well. I want to be respectful of your time, but at the same time, move the process along as quickly as possible.
Yes, I agree that it's important that we move it along quickly as possible. I personally don't have my calendar with me, but I would like to take a look at that first before I make a commitment. So I would suggest that we wait until we can regroup and look at our calendars and then set up some dates.
I would do the same. I'll submit my calendar availability to this CRMC office. Okay, with that said, then I would then entertain a motion to adjourn. Motion's been made by Mr. Gagnon. Is there a second?
Second.
Seconded by Ms. Reynolds. All in favor, say aye.
Aye.
Aye. Anyone opposed? Motion carries. Thank you, everyone, for the congeniality. I mean, it's contentious, and it was a full room, but everyone handled themselves well. So thank you. Drive safe. Be safe.